here and then, oh, perfect.
Yeah, yes, I certainly would. Good afternoon, everybody. Let's start with Professor Antrom.
Here.
Dave Mendiola.
Here.
Chris June Kiliani. I knew she was going to be here, but she was going to be in by phone. Okay, Bevan Lister.
I am here.
I'm
Laura,
seeing,
I'm sorry.
pardon me, I'm seeing Chris G joining now, so we could circle back to her.
Okay, Chris June Kiliani. I see her on, but
Okay, I had to unmute. I'm here.
okay. Laura Fitzsimmons.
Here.
Rob Tellis.
I'm here. Hello.
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 Joni Eastley.
Yep.
Jeff Wells.
Hi there.
Drew Christensen.
Here.
Kate Thomas. I believe she's supposed to be here as well. I'll keep a lookout for her. Justice William Moppin. We have 9 so far.
Okay, but 7 is a quorum, right? So I think we're good to proceed.
Right.
That's
Good.
great. Okay, so we will look out for those additional people and recognize them when they join us, if they do. So I think our first item is to open up for public comment. So people can, who are I see there are a number of people joining us. If there is a public comment, we're welcome to take it. Ms. Atanasio, did we get any comments that were emailed to us ahead of the meeting?
None.
Okay. Is there anyone who would like?
I just checked again.
Thank you. Is there anyone who would like to make, who's joining us and would like to make a public comment before we move on? Okay, seeing none, we'll also have public comment at the end of the meeting. So we'll open it up for at that point too. Okay, so number 3 on our agenda is to approve the minutes from our June 23rd meeting. Anyone, any comments on the meeting, on the minutes, pardon me?
Madam Chair, I thought they looked good, and this is Joni Eastley. I'll make a motion to approve.
Is there a second?
Chris, second.
Okay, we have a second from, I think that was from Chris G. All those in favor of approving the minutes from June 23rd, say aye.
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 Any opposed? Okay, thank you. So we're going to move on to the first item for is we're actually going to take out of order, and we're going to go to number 7 on our agenda, which is the update from the department. And Marcy, I'll hand it over to you, but I understand this might be Jared and Tom, so just I'll let you deal with that. Thanks.
That's correct, Chair. Jared and Tom are going to talk about the extern and the volunteers that we had over the summer. So Jared, did you want to take that away?
Sure, thank you. Jared Hickman for the record. I'll start by just briefly addressing and acknowledging and commenting upon the work that 4 students did with me over the summer break. And looking at the roster, it looks like only 1 is here. Nick, you want to turn your camera on? There he is. So sorry to call you out like that, but we'll start with Nick. Nick did work in two capacities for us over the summer break. The first thing he did was review and prepare a summary of the 2021 legislative session pertaining to criminal law and procedure. That summary was turned into a document that was used during a presentation with both the Clark County Public Defender and Clark County Special Public Defender offices, and providing legislative updates to attorneys across the state, but particularly in Clark County on that instance. In addition to that, he worked on our practice outline, particularly the competency to stand trial section, and completed that. Although he is starting the fall semester, he does indicate that he's willing to work with us again over the winter break. So we really appreciate his contributions. They were outstanding, and would like to thank him for his work.
Thank you.
In addition to that, looking through the list here, I don't see the other two that were working with me, but I definitely want to mention them. Harrison Bond, in between his 1L and 2L years, he also worked on the practice outline, completed a section on pretrial release, and began a section on constitutional and statutory speedy trial rights. Those will be reviewed, edited, and submitted for that final product. Crystal Folishade is another one of our outstanding interns. She is unavailable and will not be here today. She worked on our practice outline, including initial proceedings to commitment and right to counsel. She also did a research and review of prior funded Burn JAG grant applications related to training programs that we turned around and utilized in our application process. She also did very outstanding work, and we appreciate her contributions. She is going into her 3L year, and I'm actually meeting with her Friday for continued work in the fall semester. So we certainly appreciate her efforts. Servando Martinez is the third student that worked with us, the fourth student that worked with us. He also did work on the practice outline, specifically available pleas and dispositions without trial. He is a 1L going into his 2L year and did great work for us, and we appreciate his contribution as well. For our fourth student, our extern, I'm going to turn it over to Tom, as he did most of the work with Emily.
Hi, thanks. Yeah, Emily Driscoll, who's joining us, but she informs us that she may not be able to speak. I don't know, Emily, if you can turn on your camera, if you can speak, please feel free to. Otherwise, I'll just give the brief synopsis. Emily is a 3L. She was our summer extern, and she was able to help us in a number of different ways. She's incredibly resourceful and dependable. And so she worked with our data analyst in creating surveys for our mandatory surveys for client satisfaction, as well as attorney self-review and supervisor review. She also had a big part in doing our wage salary survey. We will use that and some of the other data and research she did in our BDR efforts to increase the hourly fees for appointed counsel in the next session. Last, she worked with us to develop ideas for our kind of pipeline program with Boyd in educating law students about indigent defense and other work in the rural counties, and our efforts to sort of introduce, like I said, a pipeline effort to that. So anyway, working with Emily was great, like I said. So we appreciate all of the interns and externs' work. They were really useful to the department.
Just want to say how wonderful it is. Were you outnumbered with externs and interns compared to the staff in the office?
There were more externs and interns than interns here, yeah.
No, it's really wonderful. I mean, I'm so proud of our students. They're really lucky to work so closely with all of you. And it sounds like their work was like as diverse as the department, working on administrative stuff and legislative, sort of stuff, and doctrinal stuff to help support the attorneys doing this work. So, I mean, it's a reflection of all that you do, but we're really pleased to see all of this work happening and have our students exposed to it and helping out. And I think this was your first summer being an externship placement. Is that right?
It was.
So yeah, so that's a nice development as well, that you're sort of an official externship placement. So these are sort of the pioneering students, but there'll be more. So that's exciting.
And Chair, to circle back, I see that it looks like Harrison Bond has just joined us.
Oh, great.
Harrison, if you want to turn on your camera for a second, just to be recognized. There he is.
Sorry, I was just taking my dog out, just get home from class.
So thank you, everyone. Just thank you for all of that work, and thank you to the department for supporting all the students who get supervised when they're doing all of that work. So that's really wonderful.
It was fantastic work all the way around. Thank you so much. And it was very, very important and very integral to the process. So thanks, and we appreciate it. Look forward to working with students and especially our repeat volunteers as time goes on.
That's great. Okay, Marcy, you want to, are you going on with the rest of your report, Marcy?
I can.
Or should
mean,
we
I
come
think-
back in?
I think we already covered the change in the board members that we should expect to have them at the next board meeting. So we'll have more information and that can be sent out to the members. So that's basically what we have for the update today.
Okay, great. That was wonderful. So we are slated today to have a public workshop on the proposed regulations. Does one of you want to, am I handing it back to you, Marcy, to introduce the workshop?
Yes.
Thank you.
So we provided our notice of a workshop and we've sent out our revised proposed regulation on the Board on Indigent Defense Services. And these are substantially similar to our temporary regulations. There was some numbering that was off. And the reasoning is that they took out definitions that were already in the NRS for board and department. And in some areas, a regulation that might have been, a subsection 1 and subsection 2, they've split them into different subsections. So the areas that were changed, I've provided to the board. It's also attached as an attachment for our meeting. And it does highlight the areas that were changed from the original. So as we know, sections 1 through section 8, those are definitions. Everything is the same except for section 8, which was previously section 10. The language that we asked to have added on is the definition of the plan, to ask counties to also give us the cost for the cost to carry out the plan, to include that with the definition of the plan. We felt that was important so that we'd be able to let the state know how much we expected each county to spend, and we could apply it for our maximum contribution formula. So that was the reason that change was made. Moving on to the next section, the declaratory rulings and petitions for decision-making, sections 10 through 15. The areas that were changed was the time frame in section 11 and 13, so that we would have 90 days to respond rather than 60 or 30. Just with the size of our department, we didn't know if we'd be able to meet those timeframes, especially considering the fact that we don't always meet on a monthly basis and the board would need to have input in some of that. Moving on to sections 16 through 19. I don't know if there was a comment. The only area that was changed, actually none of the maximum contribution was changed from the original. And sections 20 through 27 is where we discuss the plans for the provision of indigent defense services. We did modify language, which is now section 20. It was previously section 22. And our intent was to clarify that we wanted each county to submit a plan, and that after those initial plans were provided, that they continue to submit those plans on a yearly basis. So we just added language to clarify that. And section 23, we added language that there recently was a change in the law where initial appearances will start to take place within 48 hours. The Davis requirement was that you had to be screened within 48 hours. So we wanted to just update the language in section 23, which was previously section 25, to have the screening occur prior to that arraignment or first appearance, but not later than 48 hours after arrest.
So Marcy, do you want comments along the way, or do you want to go through the whole thing and then do comments?
Yeah, that's a great question.
It's up to the chair. What would you prefer?
I think if it's okay, we should just, we only have we only have a few more. I would prefer to go all the way through and then we'll kind of double back if that's okay. Thank you.
Going back to that, sections 28 through 37 discuss the attorney qualifications, training, and education. We did change section 32 so that category B felonies where the penalty was 10 years or less were lumped into the category B, C, D, E, or gross misdemeanor. The majority of category B felonies are those category Bs where they're facing up to a maximum of 10 years. That was always our intention originally. So we felt it was more appropriate to modify that language so that those attorneys could handle those very common category Bs. And because of the change in section 32, we had to change section 33 to be comparable. Going to the audit, investigation, and review, as the board is aware, we're in the process of developing our oversight and review process. And we felt the language that was previously in section 40 was too limiting because it had a lot of time constraints in it. So we felt it best to just cross out a lot of that language. And then as time goes on and we develop this oversight, we can put it into a regulation. Sections 39 through 40 talk about contract terms. We wanted to, in section 39, previously section 41, we wanted to clarify that compensation salary, that what the attorney receives should be in parity with the corresponding prosecutor's office that appears adverse to the public defender in those criminal proceedings, just to provide a little more clarification in what we're looking at there. In section 40, as we were working with counties that were writing their contracts, having them identify the appointing authority didn't really seem like it was necessary for a contract. It was more necessary to limit it to the contracting authority and the contractor. So that's why we crossed out the language of having them identify the appointing authority. That's more appropriate in the plans. Section 41 through 45 are uniform data collection. And as you look here, there has been some changes in the numbering because for our temporary regulations, they did modify the sections and where they were placement wise. So section 43, and I misstated it on my my piece of paper. I put section 44, but it's actually 43. We did modify the language so that it was consistent with what we had said earlier. We fixed some areas that maybe there was a typo, and that was our intention there. And then finally, we added clarification on how time should be recorded in tenths of an hour or in 6-minute increments for section 44, because that's how legal server keeps time, in tenths of an hour, so that we would have uniformity and consistency in how attorneys were reporting. So that's just the overview or the synopsis of the changes that the department had made originally and why there are changes from the temporary regulations to the proposed regulations we have today.
Excellent. So we have, the next thing is to consider, you know, we could open it up to comment, but my inclination maybe is to at least hear Jeff Wells and then anyone else who has a question before we get to before we open it up to the public and participants who are on the phone. So Jeff, do you want to comment?
Sure. And first I owe Marcy an apology because I didn't really read all of this stuff till she sent it. Well, she sent it last night, but I didn't read it till this morning. So she doesn't know what's coming. So I didn't get to alert her. You'll be pleased to know I only have 2 of them that I want to complain about. The new section 23. And that second sentence now reads, or would be, is proposed to read, the process of screening for indigency must occur prior to the initial arraignment/appearance and not later than 48 hours, etc. As you know, down here, that's actually 2 different hearings. We have an initial appearance court, which is not an arraignment. That's just really a bail setting opportunity. and then we have arraignment. Normally where this would occur is in between those two, particularly when we start bringing our rural courts into the Valdez world and trying to do the initial appearance at the 48 hours. So I don't really like this language because they are in fact two different ones. And the local court is trying to do the little blue sheets sometimes at the thing. And so at one point I thought maybe we could change this to simply say it shall occur prior to or at the initial arraignment / appearance and not later than 48 hours after arrest. But then you would have to delete the words excluding the judiciary, because if you're doing it at the initial appearance, actually the judiciary would be participating in it. But even that doesn't totally fit the problem when initial appearance, our IA court, and the arraignment are two different things. And the way this is written, it implies one hearing, and really we have two different appearances. And so I'm open for suggestions on how to fix that sentence, but that's the concern with that sentence. And do you want to have sort of group discussion, Ann, on this now, or do you want me to just go ahead and point out what my other topic is and then we open it up again?
I think we are going to have a group discussion on this, but why don't you just flag your other issue and then we can circle back.
Sure.
Thanks.
The second one is section 39. And I'm marginally hesitant to bring this up because I created a huge firestorm back during the legislative session when I was trying to make a simple statutory change. But in point of fact, I think this language is inconsistent with NRS 288. Now, Kate up in Washoe was smarter than me, and she managed to get her public defenders and her DAs to be in one union. So they have one contract, and she's going to be able to get all those people to have the parity. But we have two separate contracts. We have two separate bargaining units. And quite frankly, the public defender bargaining unit might intentionally negotiate a contract that's lower in wages 1 year in exchange for higher benefits or future something. And this last year, because of COVID, we actually had two separate pay scales. We had the county switch to save money from a 40-hour work week to a 38-hour work week, which basically meant everybody took a 5% pay cut. Public defenders adopted that in their collective bargaining agreement. The district attorneys did not, because district court stayed functioning on a 5-day-a-week calendar. So they stayed at 40 hours working and only cut their pay by 1%. So quite literally, for an entire 12 months, we did not have parity. They were making a different dollar amount per hour. They were working different hours. Both were fully negotiated with their collective bargaining agreements consistent with 288. I just don't know how, when we have two separate unions and they have rights to bargain under 288, we can be compelled to make them exactly the same at all times. Those are our two issues.
Okay, so I think we're going to have to deal with these separately. Obviously, I want to get to Christy to hear her comment, and I definitely would like to hear from, as I know we have some public defenders who are joining us. So as we move along through the comments, I think I would like to hear from them as well, really on both points in terms of getting correct the initial arraignment and the parity issue. Okay, Chris G.
Thank you. My question was on 39, so maybe it is again on salary. So maybe in this discussion with Jeff, that my question about the wording there will be answered. So I'd rather listen to a little bit more discussion. Thank you.
Okay, so we have those two comments. Are there other comments that anyone from the board initially would like to flag?
Madam Chair, Joni Eastley in Tonopah. I agree with Jeff on section 23. I was confused about that because of timing And I had one other question, but Marcy already covered that. I wondered about the extension of time in sections 11 and 13, but she explained that. Thank you.
Okay, okay, very good. So can we let's focus first on the initial arraignment and then on the salary issue. And I imagine, I'm not sure if some of the participants, I would like to maybe from the public address the initial, if we could go and address that issue first, and then we can circle back to other issues that you're flagging. But it would be useful to kind of focus on these 2 points. And if you're chiming in on this, maybe you could say whether I should be coming back to you later, if that would work. So are there people on the line who have views on this or suggestions about what would work? Nothing. Okay, so on the initial appearance, I guess I'm a little bit confused about what the new change in the law is and sort of how we best, I mean, it seems to me that I want this to mirror what the new law says, which I think was the DID's goal, right, in adjusting this. I don't want to sort of screw up good things that are happening or create new requirements, but that's not workable in places like Clark County. So what is I guess maybe you could, Marcy, you could refresh us on what the law says, or Jared, whoever's worked on this, what the law says and what you were trying to reflect in the law, because my sense is that getting that baseline issue correct is probably what we should have in our regulations. And if there's an earlier appearance, then we'll just work practically from what that says.
Thank you, Chair. I can address the first part of this. So when we're reaching out and we're talking to the rural counties and how they're appointing counsel at this point, in some of the counties, it doesn't happen until that 72-hour arraignment hearing. So you don't have to be seen in front of the judge until 72 judicial hours. And at that point, that's where sometimes questions were being asked to see if they qualified for the public defender. And if they did, the public defender would be appointed at that point. But if a public defender didn't have notice of that or didn't know they'd be appointed, they didn't have the opportunity to talk to the client beforehand and be prepared to make an argument regarding detention. So what we were intending to do is in the rural counties, have the opportunity for these individuals, once they're arrested, to have the counties send someone down to talk to them, to have them go over that form to see if they qualify for the public defender. If they qualified for the public defender, or if they appeared to qualify for the public defender, what we're encouraging them to do is let the public defender know, because ultimately the choice to appoint would be up to the judge. But at least the public defender would know, I need to go talk to someone or this person about their hearing. Some of these smaller counties don't have in custody arraignments every day. They don't represent every person that's at these arraignments, but some of the counties only have one person that may not live in the county. So we wanted to make sure that these attorneys had notice if they were going to be appointed or likely appointed, so that they could go talk to that person and be prepared to make that detention hearing. So ultimately, with the writing of this, we wanted to make sure that that was done before that initial hearing, which with the change of the law starting July 1, will have to occur within 48 hours. And when that occurs at 48 hours, like I said, some of these public defenders, they are one person doing public defense in these rural counties, and we want to make sure that they know if they need to show up that day or not. So that was the intention in writing it. The small counties aren't necessarily like Clark, where they have multiple hearings. My understanding, it appears, is that, you know, that first hearing is that initial arraignment where they are advised of the charges, and then the public defender is making those detention arguments to release their client. So that was the intention, to keep our 48-hour requirement, which is a requirement from Davis, but also modify it so that it is applicable when that law changes in July.
And so, and the problem that we have is that we were doing our initial appearance court. We do it twice a day, 7 days a week. We were frequently seeing the majority of these folks in less than 24 hours. We, in fact, have the public defender present at all of the main Las Vegas Justice Court cases. and they just do a limited appearance in 100% of the cases to make the bail argument consistent with Valdez. Of course, now Valdez came out and said within a reasonable time. The legislature picked 48 hours, but it was primarily the 48 hours relating to the Valdez portion of it, not automatically relating to the screening of whether the public defender should be appointed thereafter. Nevertheless, we provided 100%. Now, we're probably going to do the same thing with our one judge courts, because we have 8 of them out in the more rural areas of Clark County. And so we will be doing that through a video conferencing type approach.
When you say the same thing, you mean getting them seen within 24 hours or
Yes,
twice a day?
probably,
Okay.
probably, yeah. There's one of the outline was thinking about trying to do a skip Friday, but do a Saturday and Monday schedule, so they'd skip Friday and Sunday. So some of theirs would be in 24 and some of those would be in 48, but so I can't promise they would all be in 24. And even downtown, they're not all done in 24. It's just the opportunity is done in 24. Sometimes they are passed. Now, those are not arraignment proceedings. They are just initial appearance and bail setting proceedings. And that was part of my comment about that. It would seem to me we could change this, that it has to occur prior to or at the earliest of either the initial arraignment or initial appearance, and some phrasing like that might satisfy this. And the or at least would allow the screening and blue sheet to be done then, because ultimately there's a statute somewhere that says it's ultimately the court that makes the decision on whether the person qualifies or not. Now, the Supreme Court has helped that by coming up with some of their rules that says if they're getting aid under any of these programs, they automatically qualify, et cetera. But
So just to go first to that initial appearance language and then to the judiciary to split those up. Would that work for you? Must occur prior. What did you say again?
I said prior to, comma, or at the earlier of the initial appearance or initial arraignment proceeding, and not later than 48 hours.
Okay.
I didn't write that down, so hopefully somebody else did.
Do you have that, Marcy? Is there anyone, I mean, just to discuss that particular point, does that wording work? It does seem to capture the 48 hours, which is at least the baseline requirement, but captures sort of whatever that first appearance is, if it's whatever it's called and whatever's happening at it, it'll be at prior to or at that appearance. Is that okay? And I guess, can you, Marcy, can you explain the excluding the judiciary and whether that's required? I mean, doesn't Davis require that sort of information about like the screening information?
Yes.
And who's giving that? Who is it specific who's giving out the information, or can you just review that point?
The screening is only to determine whether or not they would likely, fill out the paperwork of whether or not they qualify. I think there is literature that recommends that the judiciary should be excluded from that, going and gathering that information, and that it's better to have an independent individual. And that's the concern. If it's allowed to happen at the initial arraignment or appearance, would that still exclude the judiciary, or would we strike that language as well? We have heard that some judges would like to ask this, on the record and gather this data, but then on the flip side of that, the public defenders wouldn't really have that notice of whether they need to appear that day. And I guess they would just have to appear every day for every hearing if there was a delay. That's just something that we've experienced. There are some counties where there's one attorney that will handle everything. Just a thought.
I just don't want to end up with a system where we actually end up delaying a person getting an initial appearance down here in 12 hours because while we've done the NPR, they haven't done the full screening yet. And under that language, we're gonna have to say, oh, no, too bad, you gotta spend the night because we didn't have time to do that part of this.
Mhm.
So if we modify that, would you like to delete the exclude the judiciary
I
and
think,
allow
yeah,
them to do it?
I think you have to, if you're going to allow it to occur at the initial appearance. Now, that definition of added could be as simple as the public defender that's there or the court clerk hands the person the blue form and they fill it out. Well, we call it a blue form. I don't know what the rest of the state calls it. And, you know, they check right on it that they're getting food stamps and they're getting Section 8. Well, they automatically qualify. There's not really any involvement for the judge after that anyhow, because it's clear. They automatically get it. So, and they could hand that, they fill it out, hand it to the clerk, she hands it to the judge, and the judge then moves on to the bail hearing, which is what they were really there for in the first place.
I do worry that if we exclude the judiciary, we're sort of setting us up. I mean, we need that judicial finding of whether this person can afford an attorney. And so it does sort of create a little bit of confusion. And I suspect that there are some judges who just ask a basic question, like, can you afford an attorney? There's others who are using a form, you know, where there's a risk of people putting something more, but it should be streamlined if they're following the statute. So I think excluding it is probably better. As long as we're, you know, like we're not running afoul of Davis, I think that's probably, I'm just worried about it creating a confusion.
Okay,
You meaning to exclude the word exclude.
so we would cross
Say
out the
after
section
arrest and describe the person or agency responsible. Good.
Right. I made a bad joke. I'm sorry.
Yes, it's okay. Okay, so Marcy, do you think you have the language that you need on that first part too?
Yes.
Okay, so so I want to circle back to the salary issue and ask just first, we've had this issue flagged. Is there anyone who's attending who has a, you know, either a comment to share or a suggestion about the salary issue? Okay, so let's look at that language. I guess I'm a little worried because we've run into this before, and I know that there's understandably like sensitivity from the, you know, from Washoe and Clark on this issue, and the parity sort of captures the spirit, but I understand your concern about it being like a technical term or something that maybe is worrisome. But I guess my, you know, I even wonder, like, you're just the way that you described this situation of a divergence from parity seemed to be at the option of each of the offices and not necessarily sort of based, you know, sort of it operated from the beginning starting point of parity that you were discussing, Jeff. I'm just not, I want to capture that because I know it's a really important value that already exists in the big counties and hopefully will exist in the other counties.
So, I mean, I think we could say, I thought the old language could get there, but I think you could say here approximate parity. I mean, the Webster's Dictionary defines parity as being equal to. So I don't want to create a standard that everything has to be equal to. And while our existing two contracts down here have the identical pay scales, they are different and have been from the very beginning, slightly different, each one having some provisions that are slightly better than the other folks' provisions. And then if we're going to leave in the phrase something like approximate parity, but then, you know, we need to have a caveat, you know, subject to the ability of the.
How about equivalent to?
Well, it's not always equivalent though, because again, for example, the phrasing up above says reasonable salary, benefits, and resources. All right. Our district attorney's office will have process servers. process servers don't exist in public defenders' offices. I mean, we have to give them other employees that are different. I mean, those, because they're, I mean, I'm just giving a random example. The goal, I'm sure here, is public defender attorneys want, in general concept, their salaries to be the same as the DAs, and Clark County's always had that. But we have recent examples where through the collective bargaining process, they come out different. So maybe we just have this, you know, the subject to the approximate parity, you know, subject to, you know,
The subject,
collective
yeah,
bargaining.
Jeff say subject to the negotiated agreement. And then that way the negotiated agreement that they were equal partners in may delineate it differently.
Right.
Madam Chair, this is Devin Lister.
Go ahead, please, Mr. Lister.
So curious discussion, and one, this is an area that I had some concern with in the regulation as well, in that, so the Lincoln County District Attorney is paid a salary set by the state, and he handles all of the criminal and civil and contractual and everything else for Lincoln County. He is the sole attorney in his office. And are we suggesting that we need to pay the public defender, who has a practice of his own and is able to do other things, a comparable salary to what we're paying the district attorney? I'm having a real struggle with this concept at the small county level.
Mm-hmm.
Actually, I think he makes an excellent point. I hadn't realized that they only had the one DA in the office. I think that may help explain why the old language is there. Where
It does, but except that the old language was also problematic because, you know, like, because some of those pay scales at the state level are just so different from the county pay scales, and so county employees don't want the, you know, the Nevada, like the state pay scale kind of setting being the template or the comparison.
I can assure you our public defender's office does not want the state public defender's salaries.
Correct. That's why
I can assure you that the state public defender's attorneys would like the county defender attorneys.
But I guess, you know, I guess what Mr. Lister's comments, you know, is basically saying is equivalent for equivalent duties, right? Or equivalent work. But I'm just hesitant. I guess, let me just go back to a different question. Where did the language of parity come from? Did that come from an earlier discussion?
I vaguely remember something about parity amongst state employees. Like currently, Attorney General's office employees make more than the state public defender's office. So I think, and I could be wrong, but to me, it was parity across the board for state employees.
Mm-hmm. Marcy or Jared, has parity been, is parity, I can't tell from my draft, is parity new, or is it that's always been in the reg?
That language is new.
Okay.
During the, I don't want to say fallout, but during the discussions regarding this regulation and the larger county offices early on, one of the comments that was suggested to us was that, you know, we understand that parity is what you're after. Why don't you just say that rather than, you know, dance around it? So in doing a little research, we pulled this language from the Equal Defense Act that was proposed, but ultimately did not pass in the, you know, for federal public defenders. So that's where the language came from.
Madam Chair, it's Laura.
Yes.
I think it's a really good point. I mean, if we look at Lyon County, you know, that DA is wearing two hats. He's probably advising the electeds and the commissions, and he's engaged in civil litigation. Is there something like, you know, for comparable caseloads or whatever, and that would then fold back in to your public defender's caseloads? I mean, but it's a really good point. I think.
Are you saying like the point about Lincoln County is a good point, or the point about parity is a good point?
No, I'm sorry. I think it's a really good point that if I'm a district attorney and I don't have, that's all I can be, right?
Mm-hmm.
That's true. And I can't have a private practice. And in addition to the criminal work, I'm doing a bunch of civil work, which happens in those counties. Somehow we have to adjust for that. I think.
Right. It's just that you run into problems when you talk about like caseloads, because the way that one prosecution case is very different from one defense case. So I would be very hesitant to sort of make any effort at quantifying that. And I think we create some issue if we're trying to.
I agree. But if you say, I don't know, but I just think that problem needs to be addressed. I don't have any bright ideas on how it should be.
Jonelle Thomas, I see that you have a hand up. So can you enlighten?
Yeah, if I may, I was going to make that point that workload is different than caseload. And if you use the term workload, I would not be offended. I remind prosecutors all the time that they can negotiate cases without client approval. And I don't have that ability. I too could handle 60 cases if I didn't have to consult with the client. But I'm really afraid of that caseload word on the parity issue.
Mm-hmm. Right.
And I agree with Janelle on that. I do think Bevan's point is a very valid point. I don't think we should tie it to caseload though.
Right.
I think the only thing that I would add is in the case of Lincoln County, where it's not a full-time prosecutor, once we find out, is that a 3-quarter contract or whatever it is, you could take that into consideration for what parity actually is. But as we've reached out to the public defenders in the rural counties, they across the board pretty much make less than the district attorney that they're on the other side of, and they're full-time public defenders. So just a little information.
Right. So I think that like we probably need a little bit of I think we should keep the word parity actually. And I think that if we're modifying this, that's not the word we should change. I think that the words that maybe we should be adding are subject to negotiation of the office and or for, equivalent, some kind of equivalent workload or, full-time, if there's a full-time standard. Chris?
Yeah, I think that's where I would go too. I think parity sets a standard, or at least an understanding. Maybe we need to go back to definitions and include parity and have parity subject to shall be considered X, Y, and Z. So at least there's a framework there. So maybe that'll just make it more confusing. I'm not trying to do that, but
I guess I'm wondering how much we should do now with this regulation, because we're talking about something that would, introduce, like there's some fine-tuned points that I think we want to get right. And I'm wondering if that should come now, sort of off making, sort of wordsmithing right on the spot, or if we should actually, how we feel about this as articulated standard that gets modified as we.
Yeah, that's valid. I don't want to throw this out. Maybe we delete the word reasonable and put equitable in there. And then we'll fight that out down the road, but it makes it clear what the intent is. Because I don't know what the heck reasonable means.
Well, you can say the same thing for equitable, in my opinion, because whose definition of equitable? The counties or the public defenders?
I'm wondering if we should add something after, which is that is in parity for a full-time position with the corresponding prosecutor's office, so that it sort of creates what is a one-to-one, but you could modify a little bit on when you have someone who's, if it's not one-to-one.
So Anne,
Hmm.
I'm thinking we can solve part of the problem by just at the very beginning of the sentence saying, subject to negotiated collective bargaining agreements, comma, and then you lead right into it. An attorney who receives a salary for providing a defense is entitled to receive and whatever word you want to put in there if it's not reasonable, salary, benefits, and resources that is in. And I think we could still say either approximate parity, equivalent parity, or some other word there. So we modify that with the corresponding prosecutors, and then if you want to add your workload thing, you would put it after that. But that way we get the bargaining thing up front, then we go forward. So I probably would have picked approximate parity, but equivalent parity is okay with me. But I don't know that equivalent parity is anything different. Parity.
Jeff, what about comparable to?
Okay.
Oh,
That could
you
be,
mean instead of parity?
I'm just throwing out another suggestion.
Mm-hmm. But I mean, that's what you mean, comparable to in lieu of parity as
Yeah,
a substitute.
right.
Drafting
Yeah.
word. Well, I would like to hear from other people in terms of how you feel about this. I mean, I think this subject to negotiated collective bargaining, comma, is an easy thing to add. I think, I personally think that we should just leave the word parity. I think it is setting a benchmark and there may be deviation from the benchmark, but I think the benchmark is the message. And then I'm not sure if we want to add, if we want to caveat that with, based on a full-time position or based on workload. I think that based on workload, introduces a whole bunch of sort of wrangling that could be messy. And I'm actually just not sure we want to do that right now, or whether we should adjust later to see what where people want to go with this.
this is Chris again. Can I just, I think we're getting closer. I think by Jeff realigning the collective bargaining, but that's only 2 counties that have collective bargaining. So then what happens to the rest? So maybe there needs to be addition of a sentence that says absent a contract, the intent is for parity or comparable pay, workload, da, 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 da. So it almost, you're segregating for those who have a bargaining right versus those who have chosen not to, or they're just too small to have one.
So let me try one more sentence that's a one sentence, although I don't oppose to flipping it to the 2 sentences, as Chris just said. I would start with new language, subject to negotiated collective bargaining agreements, comma. Then we go with what's on the paper. An attorney who receives a salary for providing indigent defense services is entitled to receive a reasonable salary, benefits, and resources that is in parity, comma, based on equivalent workload, comma, with the corresponding prosecutor's office that appears, and then just the rest of the language there. That way we don't modify the word parity. We try to address Bevan's issue where it's based on an equivalent workload, because it wasn't in his example when the DA is doing all that extra work. You solve the problem if you have a collective bargaining agreement. If you don't have it, then that first opening phrase I had wouldn't matter because there wouldn't be one. So that's an offer to try to solve both problems simultaneously.
So I think that that's intriguing, and I worry a little bit about workload and whether that's whether I just worry about workload. I mean, our workload study might be defining what is a workload in a full-time position and what is a workload, going to Jonelle Thomas's point, right? What is a workload in a full-time position for a defender is something we maybe need to define as, I don't care what you're doing, prosecutor, this person deserves this parity.
Right. How about based on equivalent duties?
No, I think workload is good. I mean, I think workload is the term of art that we will need to define it, right? I don't know that we need to define it now, but I think that's the point of the workload study, right? Is actually driving down what people what's expected of people so that you drive up the level of the work. But okay, so how do others feel about this proposal?
If it gets us closer, I think it gets us closer. I'm still trying to wrap my head around about, and I think Jonelle just said Elko may have a collective bargaining. Does that leave anybody out? I guess I want to make sure we don't leave others out.
And I want to just make sure that I completely understand what we're talking about. We're talking about CBAs for deputy district attorneys, correct?
Joni, or public defenders. We have two collective
Okay,
bargaining.
got it. Yeah, okay, got it.
Mm-hmm. Okay. I mean, I feel pretty comfortable with that language. I guess Marcy and Jared, I'm just looking to you for additional.
One thing that I would add is we did pass Assembly Bill 480. And in there, we did modify NRS 260.040 and stated that the compensation of the public defender must be fixed by the Board of Commissioners, and in counties whose population is less than 100,000 must comply with the regulations. So I guess the question would be, is this regulation necessarily applying to counties with a population over 100,000? Do we need to have that language in there that's being proposed? There are collective bargaining agreements in Elko. But I think the rest are set.
You might end up with a collective bargaining agreement someplace else, though, at some point, you know. I know we'd feel better having the subject to collective bargaining in here in the first place. I'm curious, Janelle, what you think about this suggestion.
Me too.
I'm going to put on my former union boss hat for a second. Parity was a very important principle to us when we were doing the bargaining, and all of my research showed that is best practices for a public defender's office. I think it gets more complicated when you're dealing with contracts versus employees. Like having parity between benefits, and certainly people who can maintain a practice in addition to their contract. In some ways, I think it was a lot easier in Clark County where everyone was an employee. They were all getting the same benefits. I don't know what the solution is, but I do think if people are working roughly equivalent hours, that they should have roughly equivalent pay. And even our recent COVID example, Jeff, correct me if I'm wrong, but I think the hourly rate was still the same between the two bargaining units. It was just that the public defenders were, in theory, working 36 hours a week while the DAs were working 40. The public defenders were also 4 days a week.
No, actually.
Was the hourly
no.
rate different?
Yeah, actually, the public defenders were making a higher hourly rate because they were taking the higher rate at only 36 hours, excuse me, 38 hours.
That's right.
The
The
higher
DAs
hourly
didn't
rate
get
at
the
38
raise.
hours. The DAs were working 40 hours, but at a slightly lower rate. The DAs ended up making more money, but the hourly rate was higher for the public defenders briefly during that 1 year.
And this is going back years, I think Elko and Washoe, both sets of public attorneys are on the same contract.
Well, I know that's true for Kate. I don't know Elko.
I think that's true for Elko. And Jared saying yes, and I would believe him, but
So I have a question about the subject to negotiated. I mean, we have a law that says in basically the new 480 says basically with the exception of Clark and Washoe, whatever salary has to follow the regulation. does this additional language of subject to negotiated collective bargaining, I realize that that was designed to have slight deviations from parity, but I'm worried that it might suggest that the regulation doesn't apply to collective bargaining. And I think that's not where we want to go. We want the collective bargaining to also be based on a parity model, even if there's some deviation.
Well, then you could put the phrase as a comma after the word parity instead of at the front, if that's the concern. They'll have parity, comma, subject to negotiated collective bargaining agreement variations, comma. You could put it there and just modify the word parity.
Okay, and then my other question, I think that might be better because I don't want to be accepting someone from a regulation that applies to them under state law. That seems to create like a little bit of a wrinkle that we don't want to walk into. But I guess I'm wondering if, like, I know you said that parity means equal, but I'm wondering, does parity have give and play in the way that we're talking about, which is like, you know, if parity is the standard and that's the message, I'm just worried about like sort of having words that modify, other than the negotiated agreement that we just moved that phrase. Do we need to have something that says based on equivalent workload parity, or is that built into what parity actually is?
Well,
Chair Traum, this is Drew Christensen. You'll now brought up a good point. In theory, most of our discussions about parity revolve around the salaried employees from a particular area. You know, the Clark County, Washoe County. It's more difficult to discuss parity when you have these communities and counties that have contracts. Even within Clark County, the contracts that we provide, the actual hourly rate we pay the lawyers is higher many times than what we pay our, institutional lawyers. And the contracts don't provide health insurance and other kind of benefits that are within a salaried approach. The parity discussion seems to me to be more with regard to the salaried employees, and the DAs are always going to be salaried employees, typically of the county. Mm-hmm. And so maybe there needs to be a split for those counties that contract with their public defenders, where the discussion needs to be, parity is a difficult equation to come to when you have one salaried employee and one contractual employee, where it needs to be more based on supplying them the resources that the salary gave the DA to give to the contractual lawyer. So, I think later on in these regulations or in a rough draft, I saw the discussion of contracts should take into place the local council rates, the workload. I mean, there was a number of discussions on how you got to a number. So many of these counties that pay a flat number to say, take all our cases, that's our concern. Because how do you ever look at that number and say it's on parity, right? I think in Nye County, they pay the lawyers $185,000 to take everything, but their particular deputy DAs in Nye County, I'm not sure what they make. It's probably not $185,000. So my point, and so there needs to be a discussion somehow to give some kind of modifier to the term parity as it relates maybe to similarly situated employees versus similarly situated attorneys who are doing the same kind of work on a case, being paid differently. My point?
Right. Okay. But I guess, but some of that just comes out, I mean, in different ways, which is, well, you're not getting benefits. We'll give you, like, you're getting a higher hourly rate, that kind of thing. But I'm actually just wondering if it would work, and I leave it to other people to get the commas right. But I'm wondering if that is in parity, taking into account equivalent workload and subject to negotiated collective bargaining, whatever agreements, comma. Which captures the spirit of equality. I mean, there's going to be it allows deviation from strict equality based on like sort of legitimate, factors, right? But the goal is parity.
So if I understood your suggestion correctly, we would leave the sentence exactly as it is all the way up to the word parity. And then we'd say that is in parity, comma, based on equivalent workloads and subject to negotiated collective bargaining agreement variations, comma, and then the rest of the sentence would still say the same.
something along those lines.
I liked it.
I think that gets there.
Mr. Lister, does that address your concern, do you think, in the?
Yeah. I don't have it in front of me right now to where I can look at it, but I believe it'll take care of it.
Okay.
Yeah, but the reason.
And so we could also say, it could say based on equivalent workloads, it could say taking into account equivalent workloads, which is more flexible. Because you could also not take them into account. I mean, you know.
Yeah, no, that's fine.
Okay. So Marcy, do you think that you have language that would work for you?
Yes, I'm reaching out to Sophia. She was unable to make the meeting to see if that is considered to be a substantial change to the language or not. She hasn't been able to answer the question. If these are substantial changes, we need to send them back to LCD, and that may not make our timeline that we need to act within. Our temporary regulations expire November 1st.
Well, then tell her to rule that they're not substantial.
It's so easy.
It's clarifying language.
Okay. So I guess we'll hear back on that at some point. And the question, you know, I guess related to that is, based on our timing, are we, I guess, better kicking the can? But I mean, I do think if we could get this to be clarifying language, that would obviously be the best, but we'll see what she says. Okay, Jonelle Thomas.
Just one last comment, and I wish I were more familiar with other offices, but my reading of section 39 is, it seems limited to the institutional defenders, where it talks about the Office of a Public Defender. Does that section, and who receives a salary, are there salaried defenders who are county employees who are not working full-time, or are those all by contract?
I was gonna jump in and answer based on kind of Drew's question as well, but in part of that as well. We tried to split this up, and I think Jonelle is right on point. We tried to write this with the describing phrase "attorney who receives a salary" as limited to those institutional offices, and then looking in the very next section, 41 subsection J, is the phrase that tries to get parity with respect to contract indigent defense services. So if we're going to add that comparable workload language into 39, it may also need to be there as well. And, you know, just kind of an overarching comment, the workload issue, I think with our initial draft, we thought was better handled in J, because that's where the real disparity in workload happens. We've got, as Mr. Lister provided, the county employee DA who does all that work, and then the contract public defender who does a very limited subset of that work. And we tried to cover that issue with 41J. So I just wonder if we need to make a change there as well.
Can I just ask a little clarifying question? Is 41J not on the piece of paper that you sent us? Is it someplace else?
It is. So if you're looking at section, so right underneath the section 39 that we're talking about with the red writing, section 40 right underneath, if you go to the top of the page 7, J, it reads.
Yeah. I see that. I just was confused. I thought you were saying 41.
Oh, no, 40.
Okay.
Section 40, subsection 1J.
Yeah. Gotcha. Okay, sorry. Okay, so looking back at 39, refocusing, this is for a salary that's a defender salary. So I guess where does that leave us? Do we still need, but we still have, I guess I'm just not sure how counties do that, right? Like we do have prosecutors. Sometimes the prosecutor opposite, like a Clark County prosecutor is really has much more, they have much more equivalent jobs than someone who's managing every kind of litigation for the county, right? But is it still useful to have this language that we put in because of Mr. Lister's comment that we could have a salaried person in a county, right?
I mean, my thought was that in kind of thinking through that is the subject to the negotiated collective bargaining agreement language would remain in 39, but the comparable workload language might go in section 40, subsection 1J.
And there may be a problem with adding collective bargaining agreements since it's not referenced according to Sophia. I'm trying to talk to her now. She's fine with adding language regarding the workload, but there may be concern about talking about collective bargaining agreements.
And she thinks that's a substantial change.
I'm just trying to clarify with her. It's hard since she's not here.
I would argue that's an overreach in my opinion, but.
Okay, so but on 39, the only issue we have is sort of Elko, right? With respect, because we have a decent argument that the other two counties that have collective that we know about are not even subject to this, right?
Well, no, I think 39 is specifically Clark and Washoe. It's 40J that's the rest of the folks. I mean, if anything, you could almost make the argument in Bevan's case that his concern, and now that Jared's pointed it out, and I appreciate him doing it, really belongs in section 40J, doesn't belong here, because if has his defense attorneys on contract, then they aren't receiving a salary. And so you could make an argument that doesn't even apply to the rule. But it clearly does apply to at least Washoe and Clark, and maybe applies to Elko.
I guess I was confused about the way the regulations work and whether through 480 it already cut out. Maybe I misunderstood Marcy on this point. I thought through 480 we already cut out Clark and Washoe. Is that wrong, or am I wrong?
480 cuts out the salary of the public defender is supposed to be set pursuant to the regulations only in counties with a population less than 100,000. Language was limited to the smaller counties.
But that only cuts out the public defender. It doesn't cut out all the attorneys in the office. This regulation brings in all the attorneys in the office, all the deputy public defenders. And all the deputy public defenders are subject to the collective bargaining agreement.
Okay, so I guess we want to get a better clarification or final clarification from Sophia about whether collective bargaining is, whether it's a substantial change, and if there's any other way to address it that's not a substantial change, or whether we need to sort of have a more fulsome discussion about what a substantial change is.
Well, I could make the argument that it's just clarifying, because NRS 288 already exists. NRS 288 already establishes the rule of how the county has to enter into negotiations in certain times of the year, et cetera, with their collective bargaining units. These are recognized units. One of the subjects of mandatory bargaining is salary and benefits. So I could make the argument that this sentence, even if we didn't put this clarifying language in, it was subject to 288 and the word, it wouldn't matter. And so by putting in this thing, we are simply clarifying that it's subject to 288.
Correct. I agree with Jeff.
So that then is the question of whether we need the language, whether if she says it's substantial, we would be comfortable jettisoning this language about the bargaining agreements.
Well, of course, I brought it up because we really aren't going to be comfortable with jettisoning it.
Yeah. Okay.
So.
Okay. So I think we have language that we like.
I think we let Jeff talk to Sophia and explain why we think we need the language. How's that? Sorry.
It seems like it's also, another alternative to me would be if we we're able to reference a statute that brackets out certain people, then that would be a neat way of just saying we're just putting a useful reference to a law, and that wouldn't be any kind of change, right? It just is just indicating consistency, but I'm not sure that I have the language that makes that happen. So let's say everything was copacetic with this is no substantial change. Do we all feel comfortable with the language that we proposed? Because we could at least leave it there, and we might have a timing issue if we've got a substantial change, but we would, so which would be that is in parity, comma, taking into account equivalent workloads and subject to negotiated collective bargaining agreements, comma. Is everyone good with that? I think that's where we are, and we feel like that's sufficiently complete. And then we leave the sort of wrangling about whether this is a substantial change. And we also sort of, I guess one question is whether there's a workaround, another workaround that we haven't thought of.
Do you, Chair, do you need the, oh, sorry, do you need the workload language since it's already covered in section 40?
That's what I was gonna say. I think Jared made a good point that the workload can be taken out of 39.
Okay.
And just the CBA language is what we need to discuss. Workload was registered.
Okay.
And in Kevin's concern, I think it's covered by that 40.
Yes, 40J.
Section J, right.
Okay, so I think we're good with it. When we just say subject to collective bargaining agreements, and I think it's sufficiently in brackets where it would be great if it wasn't a substantial change, and it would be great if someone thinks of a way in which it is not, if there's another way of saying it that is not a substantial change, if she says it is. But I think that's where we are right now. We'd like to have that reviewed as to whether it's a substantial change, right?
Why don't we just insert after parity, like we've said, and subject to negotiated collective bargaining agreements, parentheses, NRS 288.
Okay.
Drawing attention right to it.
Okay. We'll see how that works out. I think I don't think we need to vote on this, right, Marcy? We do that later, right?
No,
This is workshopping.
you do not need to vote at all on any of this. We just said a workshop.
Okay. So having worked through those two issues,
well, on behalf of Bevan, we're still putting the workload, equivalent workload language into 40J, correct?
That's what I understood.
I'm just making
so
sure.
Actually, let's just, can someone, Marcy, do you have where that language goes in 40J if we're doing that?
I think I might.
Go ahead.
So it would read something to the effect of, going back to the prior page, such a contract must include but is not limited to the following terms. J, provide compensation at a reasonable hourly rate that is comparable to the hourly rate provided to local prosecutors with similar experience and comparable workloads, and considers overhead expenses and costs relating to significant attorney travel.
That's good.
I'm just wondering
I'm
if it's
good with
cleaner
that.
to say with similar experience and taking into account comparable workloads, comma, overhead expenses and costs, etc. Is that? I think you get rid of an extra and there. If that's NQ.
Yeah, and taking into account comparable workload, comma, overhead, comma, expenses, comma, and relating to significant attorney travel.
Costs relating to, yeah, exactly. Okay. Other than, okay, we've worked through those things. Are there any other, from the public or from the board, any other additional comments on the proposed regulations? Okay, hearing none. Marcy, do you think you could just tell us what comes next in this process? Obviously, we have the consultation with the DAG on that issue about substantial change, but.
Yes, so I think that the next step that we have to take is to schedule our public hearing. And we are proposing that we schedule that for October 6th.
Right.
We need to give 30 days notice of this, so we are asking to set it for that date. And I will talk with Sophia after the meeting and give her the information that we want changed, and then I'll advise you, Chair, what we're going to do.
Okay. So bearing that in mind, we will, this actually was going to come at the end in terms of setting our next meeting. So I think we will be setting our next meeting on October 6th to coincide so that we would then approve these regulations at that point. This is also for later, we are not having our Tonopah meeting on September 29th. This is partly because of this, we need to meet on the 6th instead, and also because of COVID. So we hope to do that in-person meeting at a later time when we feel like it's safe and will work in terms of with what we are, when we need to meet. So we'll wait to get confirmation that the October 6th date will actually work, and we'll get that out to you. Okay, very good, thank you. And thank you to Joan L. Thomas and others who are watching and participating. I mean, we really appreciate your input. Okay, can we go on to the next item, which is the complaint and recommendation procedure?
Yes. So I believe at the last meeting, we did receive public comment from an inmate, and one of the board members requested that we talk a little further about what the department's policy is or internal policy is for complaints and recommendation. One of the attachments for our board meeting today talks about our internal policy and how we're currently handling these complaints and recommendations. As we've brought up before, we don't necessarily have any sort of authority to hold any hearings or have any power as to, what to do in certain situations as a board as set by statute. So what we believe the purpose of the complaints and recommendations is for our oversight. So as you see in our internal policy, any interested person can fill out our form for a complaint or recommendation. Once that form is received, if it's about a specific attorney, what we're doing is we plan to forward it on to the attorney, the appointed council administrator, or that attorney supervisor as appropriate. And we're also going to keep a copy of that in our file for when we do oversight of that county. If it's regarding a county, we'll forward that form on to the county manager, board of commissioners, or supervisors as determined to be appropriate by our department. And we'll also keep that form in our county records to be reviewed for that oversight process. If the form does not contain a complaint or recommendation that's specific to indigent defense, we will plan to respond that it's outside of our purview and basically close that complaint. If there are complaints or recommendations that implicate possible system-wide issues that could lead to a corrective action plan, we'll take steps as determined to be appropriate by the department. So that's what we've determined to set out as our internal policies.
Good, thank you. Does anyone have a comment or question on this?
I think it's very thorough and at least responds. What most people want is at least just an acknowledgement. So, and there may be some legit issues. So sending it forward, but I don't think it's their role to get into that. So I think it accommodates what was discussed last time.
Excellent. Anyone else?
I think Chris said it all.
Good. Okay. Very good. Okay, let's move on then to what's number 6 on our agenda, which is the review of the monitor report and I guess discussion of the data analyst. So go ahead, Marcy.
Thank you. So I provided everyone with a copy of the first report from the monitor, Professor Hanan. We were actually on the phone with her this morning and she's on this meeting, as you can see. So we have made ourselves available to her when she has any questions. And I believe her second report will be coming out, or it's due at the beginning of October. So the concerns that were at the summary of the report are the adequacy of funding. She's concerned that if that $1.2 million that we have earmarked for those Davis counties is delayed in any way, she's concerned that they may be hesitant to make the changes. And she also is concerned that the $1.2 million is insufficient. So in response to that, we do have a schedule.
So are we.
Yeah, we do have a scheduled meeting with the governor's finance office in September to address these concerns. We have asked each county to let us know what they expect the indigent defense cost to be for this fiscal year so that we can take those to the governor's finance office to let them know how much money is needed. With the plans that we've seen so far, some counties have greatly increased what they expect to spend. My understanding is that Nye County might greatly increase as well because there's a possibility of a 3-defendant death penalty case there. So we need to take this information to the governor's finance office to start having these discussions. So we will have that discussion mid-September, and we should have information for the board for our meeting next month. The next concern is that we have $10,000 for in-state travel and we have no budget for out-of-state travel. Our department is planning to go to Kentucky if allowed by COVID. We'd like to go to a training there. That's for departments like ours. So we'll have to find money somewhere else to be able to do that out-of-state travel. So at this point, you know, we have to try and spend this $10,000 appropriately. And if there are concerns, we'll bring it to the board for further direction of what we should do if we in the end actually do need additional money, or if we have concerns that it's not enough. And then the final concern that she has mirrors what the data analyst said, is that we no longer have that data analyst who's been assisting us. We're an extremely small office, and she does recommend renewal of that data analyst contract. We have submitted a request with our budget analyst to renew a contract with a data analyst. What our goal is to perform a wage salary survey. So just as we had talked about what is parity, what should it be, we'd like to try and determine what a reasonable salary for a public defender in Nevada should be so that we can give more guidance to the counties. We'd also like to have an incentive program review to make a determination. Is there a shortage of attorneys in the rural counties? Some of the judges have expressed concern that what happens when we run out of attorneys on our list of approved attorneys. Some attorneys are retiring at this point, so we'll have to try and determine if there is a shortage, and if there is, what can we do to incentivize people to come into the rural counties? There's programs in other states that seem to be working, and I'd like to try and determine what would work best for Nevada and put that in place. And then finally, once we get certain things into place for oversight, like our salary or our survey, we'd like to have that data analyst assist us in being able to read those results and properly interpret them. So that's what we're requesting funding for the data analyst for. We have not had information on whether or not it's moving forward. So this is another issue that we can bring up when we meet with the governor's finance office. As for the data analyst, you can see in his report, he completed the annual reporting form. He worked with the National Center for State Courts while he was able to. He did review our funding for the maximum contribution formula, and he assisted in creating that client satisfaction survey, but he is concerned that we probably need the data analyst to look at the information as it come in and make sure that we're properly analyzing and interpreting the results and applying it to our oversight process as we're required to do pursuant to Davis. We also did put some tools in place for the attorney monitoring and system performance. But again, that presence of that data analyst will help us to properly determine how to review those forms and apply it to our observation. And then finally, as we've discussed, the wage salary survey, he did start the wage salary survey, but we did run out of time because his contract expired at the end of June. He recommends a continued contract with the data analyst, and he does point out that additional effort is needed to complete the wage salary survey, and it just wasn't completed because of insufficient time.
Marcy, do you think you could just, I know that you mentioned you're going to talk to the governor's finance office. Is that the timing question? You're waiting to get, I mean, they would approve it, or you would go to, what is the timing horizon on this? Like, what is ideally?
We have reached out. I mean, the earlier that we can get in front of the interim finance committee, the earlier we could request the funds. We will have to do a request for proposals like we did before, and that is a time-consuming process. So in our current request, we are asking that the funds be allowed to be used till the end of fiscal year 23. So the sooner that we can get this in front of IFC, the more time we'll be able to have to work with the data analyst to complete these. That was part of the problem that we had previously, is by the time the RFP was completed, we only had about 10 months to do all these things that we had set forth. And with COVID, we just weren't able to achieve it. And we spent about a third of what we had been approved for.
Right, which is part of your argument as to you need the money at plus more, but you need that money. I mean, you need that money kind of reinstated plus more, plus a longer time horizon to actually get it done. So you have the flexibility as well as the money to get it done. Okay, thank you for that. Any comments or questions about the report?
Madam Chair, just a comment. Marcy, it's Joni in Tonopah. You commented on the potential shortage of attorneys in rural Nevada, that you were going to be looking at that. I've wondered the same thing myself, but in addition to that, particularly in Nye County, I wonder if there's a shortage of death penalty certified attorneys. I don't think Nye County has a death penalty certified public defender. Am I correct on that? Do you know?
Jody, this is Drew. They've reached out to me. We're looking for attorneys here in Clark County who are willing to look, take the cases over.
Oh, good. Okay.
They've reached out, and a number of their new contracts were lawyers that we had under contract who are willing to start, going to the rurals and working more in some of the other areas of the state.
Yeah, that's great. Thank you, Drew.
And we had that discussion with the Nye County Board of Commissioners and the courts regarding their plan. While none of their contract attorneys are 250 qualified, there were several attorneys from Clark County that applied to be on the list for Nye County that are. And they have the most recent list and are aware of those entries, those attorneys that have applied with us from Clark County that do have the 250 certification or qualifications.
Good. Thank you.
So I just wanted to, I work very closely with Professor Hanan, who's a monitor, and I know that she also works with another one of our students who assists her, but we're really grateful to have the monitor in place as just another person who's very, serious and looking at what needs to be done in the state and has that broad perspective, but also will bolster the department's efforts to actually get these resources that are really desperately needed. So we're grateful to that and look forward to the next report.
Yes, thank you. And if I can just say, it's been really great working with Marcy and her team. They've been so forthcoming and available so that I have the information that I need to supply to the court regarding compliance with the judgment. And they're doing it on a shoestring budget. She correctly stated some of my concerns for compliance are really related to the funding issues. The department is doing, going to heroic ends to make it work. So, and the student I'm working with is Cindy Johnson, who's wonderful and contributed a great deal to the report. She couldn't make the meeting today. So thanks.
Thank you. Okay, can we move on to, I think we talked about future meetings. So I think we're set on that, which is we'll wait upon word that we're good to go on October 6th, which would be the correct timing for our next meeting with respect to the regulations so that we could adopt them. And that's when we would actually vote on them. So we'll wait to hear on that, but that is the plan. And I'm sure Cynthia will send out, we'll let you know, but Cynthia would send out an invitation that we've decided not to do the meeting in Tonopah, regrettably, on September 29th, because we have to meet in October. So we hope to make that happen at some point. Public comment? Anyone? Okay. So before we adjourn, I just wanted to tell everyone, sadly, with a very heavy heart, that this is Jared's last meeting. He has been, as you all know, he's going to leave the department in September or this month, I guess, now that it's September. He has just been an incredible person to work with. Really, as we were just talking about, the department does everything. There's like basically just a few people there who are doing all different kinds of things. They do administrative stuff. They do hands-on work with attorneys. They do legislative stuff. They have finance meetings. Just they figure out all these issues with workload study and data people and computer everything. And so Jared has done all of those things. We're basically ready to wrap up our second set of our temporary regulations. The first set of regulations was really his baby from the beginning, where he wrote those himself and figured out what needed to happen. And then, you know, all of the tweaks that needed to happen and all of the outreach to people in the field to make them happen. He's worked incredibly closely with our students, which I'm really grateful for. He's done an incredible job putting together a training program that is really outstanding and has really just brought so many people together in meaningful ways, and really, I think, elevated their practice and criminal defense in the state. And so we're just so grateful for everything that you've done. It might be a little bit of a lesson that we're just asking too much of the department every day in terms of what the job is. So I think that's a little bit of a caution, but I just wanted to thank you personally, Jared, and for everything that you've done for the department.
Huge loss. We will miss you, Jared.
Thank you very much. I appreciate the very kind words, and please know it's been a really great experience, and it's been very much a team effort. We've done this all together, and that's going to be, you know, one of the things I miss most.
Yeah. Well, thank you so much.
Good luck in your future. Thank you for your
Thank you,
kind.
Jared.
Thank you.
Thank you.
Yeah, thanks for your effort. I just want to say, not only this, he's a really good guy.
So yeah, thank you. That's nice to hear from everybody. I think we asked for a motion, but we don't actually need a motion to adjourn. I think we can just adjourn. Is that correct?
It is, but I always like to move it anyhow.
Okay, go ahead.
I'd
So
move we
ceremony.
adjourn.
Who would vote against it?
Right. Okay. Thank you. We are adjourned. And I look forward to seeing you in October. Take care, everyone.
Thank you.